Hi, everybody. Pete Sardis for The Lawyer You Know. We are back talking about Elizabeth Holmes because now Elizabeth Holmes is not going to prison, at least for now. I will talk about what has happened, what I'm expecting the process is going to look like, and my opinions towards the end. So with that, let's get to it. All right. For those of you that know, Elizabeth Holmes was supposed to report to prison this last Thursday. That's April 27th of 2023 to a facility in Bryan, Texas. But her lawyers filed a motion with the Ninth Circuit Court of Appeals asking the appellate court to reconsider the motion for supersedeas bond, which is the motion that she and her lawyers filed to have her stay out on bond pending the outcome of her appeal. The Ninth Circuit Court of Appeals has a rule that stays proceedings until those briefs are considered, and that's exactly what has happened here in this case. So Elizabeth Holmes' lawyers filed the motion basically saying that there is a very good chance that Elizabeth Holmes' trial and sentence may be reversed. She may then have to have a brand new trial because of the errors that occurred during her trial back in January of 2023. So what's going to happen now? The government has to file a responsive brief. The rules say that they have 10 days. So technically, their brief is due on May 3rd, and we'll see what their response is going to be. This is something that has gathered a lot of attention, not only from us and from you all, but from an organization called the National Association of Criminal Defense Lawyers, NACDL. And NACDL has filed something called an amicus or amicus brief, depending on what part of the country you're from will dictate how you pronounce that. And that brief is in support of Elizabeth Holmes' motion. And it pretty much says this. There are constitutional issues that have to be taken into consideration because Elizabeth Holmes was convicted based on evidence that is outside of the rules of what should be presented to a jury and in violation of the rules of criminal procedure. Part 2 of their amicus brief or amicus brief, depends on how you say it, is that the government did nothing more but parrot the public narrative, meaning that they were just taking whatever public perception was and spinning it inside of the courtroom. And because of all that, there is a very real possibility that Elizabeth Holmes' conviction should be overturned, that her sentence should be overturned, and that she should have a brand new trial so that all of these issues can be considered with the appropriate rules and appropriate evidentiary considerations being implemented. Now, I believe that the government's going to file a responsive brief sometime close to May 3rd, denying all of that. There is one thing, though, that did catch my attention. And the one thing that I thought was very interesting was in the amicus brief, and again, in the brief filed by Elizabeth Holmes' lawyers, they cite that during sentencing, Judge Davila made a statement. And that statement was a reference to the patient fraud convictions. Now, this very well may have been a misstatement, just they kind of came off the tongue that way. But if you recall, Elizabeth Holmes was acquitted on the counts involving all the patients. So does that mean that Judge Davila, in the course of his determination of Elizabeth Holmes' sentence, actually took into consideration the counts that Elizabeth Holmes was found not guilty on? If that's the case, there very well may be a new sentencing or a new trial in Elizabeth Holmes' future. That would be interesting. Now, let me just give you the other side of what I think the government is going to say. Judge Davila has the right to take into consideration something that's called relevant conduct. Relevant conduct is basically the conduct of the defendant relative to all of the charges of conviction. And I think that there is a fine line between considering conduct that was acquitted and considering conduct that was part of this fraud, part of the scheme that was inextricably intertwined in the counts of conviction, basically talking about providing medical services or services from the Edison machine that was supposed to quickly diagnose patients. So I think that there is a fine line between considering patient conduct, of course, or conduct involving patients, and considering conduct that was acquitted. So we shall see what the government says about that part of the brief. All right, let's talk about how the procedure happens. I will tell you that in many other federal appellate circuits, especially the ones that are more conservative, think about, for example, down here in the 11th Circuit, which is the southeastern United States, a motion like this would not even probably gather a moment's consideration. It would be denied very quickly. They probably would not even stay her self-surrender date. But the Ninth Circuit, being a little bit more liberal, actually has a rule about this. And the rule is, frankly, I think very fair. If you file it, we will consider it. So we stay anything that's supposed to happen until we have a chance to vet the issues. So what happens? Elizabeth Holmes has filed her brief. The National Association of Criminal Defense Lawyers have filed their amicus or amicus brief in support. The government, sometime around May 3rd, is going to file their brief. What will then happen is the law clerks for the individual appellate judges assigned to this matter will take the briefs and they'll break them down by issues. So if Elizabeth Holmes, let's just say for purposes of this conversation, raised 3 issues in this particular appellate brief, and let's just be clear, we are only talking about the consideration for whether or not Elizabeth Holmes should remain free on bond pending the outcome of the entire appeal. The appellate court right now is not considering the entire appeal since it hasn't actually even been filed yet. So it is limited just to whether or not she is staying out on bond pending the outcome of the appeal. What will happen is the law clerks will take all of the issues, let's say 3 issues of the plaintiff, 3 issues of the defendant of Elizabeth Holmes. They will then break down the issues that NACDL raised in support. They will then take the government's response, put those issues together by issue. So let me say it again to make sure it's clear. Elizabeth Holmes brief, issue 1, the amicus brief, issue 1, the government's answer, issue 1. Then the law clerks will put together all of the case law. They will do a memorandum for their individual appellate court judge. Now understand, each judge has their own law clerks. So they'll put it all together in a little packet. Now, I don't know if it's a binder still or if the Ninth Circuit uses it electronically, but point is, all of the issues for each of the parties will be put together for each individual issue, along with the case law that is relevant in some sort of a legal memorandum done by the law clerks. Now, understand in federal appellate courts, law clerks are actually trained and very skilled lawyers. They're not law students. They are people that do this for a living. So they are law students, normally from very good law schools, normally with very good grades, normally with a job at the federal appellate level at some point, at which point they become law clerks for the individual appellate judges that help put all this together, because at the end of the day, there's a lot of hands that are needed in order to consider all of the appeals that go through an appellate court at any given time. So when all of the issues have been briefed and all of the briefs are in and all the time has expired, the law clerks put together these little packets for the appellate judges, at which point the individual appellate judges will review what has been presented and they will make a decision. Then the appellate judges get together and they basically vote. 2 out of 3 wins. And what will then happen is they will issue an order. One of the judges will be selected to write the order. And of course, the other judges have the right to kind of add their comments if they want to dissent, meaning that they want to disagree, or if they want to join in for some other reason. And we see this a lot in appellate briefs where there's an actual appellate decision by the court. And then there's all these little subsections where the judges actually talk about, why they don't agree with this or why they do agree, but why they think that the result is correct, but for different reasons. All of that stuff is the cerebral part of the appellate process. And that kind of helps lawyers and judges kind of understand everybody's thought process in making the decisions that were made. All right. So what will happen is all of those will be taken into consideration and order will be drafted. And that order is going to be one of 2 things. It's either going to grant Elizabeth Holmes' motion in the appellate court, meaning overruling Judge Davila and allowing her to stay out on bond, or they will not do it. They will basically deny her motion and sustain Judge Davila's orders, at which point Elizabeth Holmes will have a new turn-in date. Let's talk about our chances. Supersedious bonds are rare. They are not the norm. Frankly, if I had to say it, I would suggest that they are the absolute exception. They're very infrequent. Does it happen? Sure, it happens. And that's why the process exists, because you never want to incarcerate someone who has been convicted under facts that very well may lead to a new trial or a new sentencing, because that affects the interests of justice. You want judges to be considering what other judges have done. You want the process to work properly. But realistically speaking, I think that the appellate court is going to consider all of the evidence that was presented against Elizabeth Holmes and make the determination that there is competent evidence in order to sustain a conviction, and therefore this prison sentence will stand, at which point go to prison. Now, this is not to say that she could not win an appeal. This is not to say that she could not get a new sentence, a lower sentence potentially at some future time. But for purposes of this motion, it is going to be on the limited issue on whether or not Judge Davila erred in denying her motion to stay out on bond. I will just give you some information based on what's going on the other side of this case for you to consider. Sunny Balwani's lawyers filed their own motion for him to stay out on bond. Judge Davila denied that motion. Of course, Sunny Balwani and his lawyers filed a motion to stay the prison self-surrender, which was supposed to be on March 13th. Of course, pursuant to the rules, the Ninth Circuit granted that stay and considered his motion to stay out on bond pending the outcome of the appeal. It took the appellate court 3 weeks in Sunny Balwani's case to deny his motion, at which point he was given a new self-surrender date of April 20th of 2023. Sunny Balwani has self-surrendered. Sunny Balwani is currently in federal prison. If you go to BOP, the Bureau of Prisons website, you can actually put his name down and you can see that he is in custody and that he is at this point serving his 13-year prison sentence, or at least part of it, depending on what will happen when his entire appeal comes back. I would suggest to you that Elizabeth Holmes may have better chances than Sunny Balwani, because remember, Elizabeth Holmes' trial was first. All of the errors, all of the inconsistencies, all the little hiccups and road bumps and all that stuff that happens in the course of a trial for the government all got fixed, because when they tried Elizabeth Holmes, they fixed all that. So at Sunny Balwani's trial, it was a much more streamlined, much cleaner presentation. It's just reality. They had a practice run with Elizabeth Holmes. So Sunny, basically being the second person to get tried, winds up getting a far cleaner, a more better presented trial. It's just the way it is. So from his perspective, he is now serving his prison sentence. We'll see what happens in his appeal. We'll keep you posted. But for Elizabeth Holmes, there are some issues here that are they're out there. The fact that Judge Davila said these words about patient fraud convictions, is that going to be enough for the Ninth Circuit to say, wait a minute, there very well may be a problem here? Does the appellate court, do they think that Judge Davila used the wrong standards, basically, for allowing experts to testify? Do they believe that Judge Davila violated the rules of civil criminal procedure? Do they believe that Judge Davila allowed evidence to either come to in front of the jury or exclude evidence outside of the rules of evidence in the federal court system? And that's, something that is going to be considered. I think they're going to consider this very stringently, but not right now. Right now, the question is simply, is there the possibility that these things happen? And if there is a possibility that a conviction can be overturned or a sentence can be changed, at which point they will have to issue a stay, at which point she will be out on bond pending the full completion of the appellate briefs. All right, my opinions. I don't think it's going to happen. I think within a few weeks, you're going to see a denial of Elizabeth Holmes' brief, and a new turn-in date to the Bureau of Prisons. I still think she's going to self-surrender. She's still probably going to go to Bryan, Texas, again, 100 miles away from her childhood home. And that's my opinion. What do you guys think? Do you think that this particular issue is going to be big enough to render a bond pending the outcome of her entire appeal? Meaning, will she just stay out on bond for 6 months, 8 months, a year, however long it takes? Because let's talk about the practicalities of that. If she goes to prison, her briefs are going to get filed quick. There will be I don't want to say expedited briefing schedule, but the briefing schedule is going to be based on the rules. You've got so many days to file your initial brief, it'll be filed. The government has so many days to answer. The defense is going to push them to make sure those briefs are done. The response that the defendant can do, the appellant can reply to any issues that the government raised in their brief. That's normally a short briefing schedule, like 2 weeks, 12 to 14 days, something like that. I'm sure those will get done very quickly. Now, if Elizabeth Holmes is out on bond, I'm sure there will be plenty of motions to extend the deadlines. Will the government agree to extend deadlines? I don't know. Normally, for purposes of courtesy, reasonable extensions, 30 days, for example, are not uncommon amongst the parties. And we normally grant those courtesies to each other very freely. But let's see. If she's out on bond, I'm sure the defense is going to be happy to let that just kind of go off into the sunset. Have as much time as you want. What do you need, 30 days for an extension? Take 90, no big deal. But if she's in custody, I promise you that will flip. They're going to want this briefing schedule expedited so they can get in front of the appellate judges and do the oral arguments. Presuming they ask for oral arguments, they're going to ask for oral arguments, especially in this case. And then we'll get a ruling from the Court of Appeals. So that's my opinion on how this thing is going to go down. I don't think she's going to get a supersedious bond. If she does, I think you'll see the briefing schedule change significantly. So you tell me your thoughts. I, of course, will keep my eyes on it and see what's going on. Leave me any questions and your comments down below. I definitely appreciate them because that's what I get my ideas for the material for these discussions with you. So with that, I'll keep you posted as things happen.
Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.